Civil courts should not adjudicate employment discrimination claims against religious groups when the employee's job entails a religious function.
The Supreme Court has unreasonably expanded the definition of ministry.
The American Religious Town Hall is now in session.
Welcome, friends, to the American Religious Town Hall meeting, where the discussion of religious, political, and social issues is meant to promote the cause of religious freedom and to help us better understand each other. And now, here's your host and moderator, Pastor Jerry Lutz.
Welcome to the American Religious Town Hall COVID edition. I'm here, James Weingartner, filling in for Pastor Lutz. And we've limited our panel down to 4 for some social distancing, but we still have good and important topics to discuss today, and we'd like to introduce our panelists to you. They'll introduce themselves, beginning with the gentleman on my right.
My name is Bishop Michael Olson, and I'm the Bishop of the Roman Catholic Diocese of Fort Worth, Texas.
Hi, I'm Carl TROVALL. I'm Professor of Ethics and History at Concordia University in Austin, Texas.
I'm Tom Plumbley. I'm the Senior Minister at First Christian Church in Fort Worth, Texas. I and my congregation are part of the Christian Church Disciples of Christ.
I'm Tony Matthews, and I'm the Senior Pastor at North Garland Baptist Fellowship in Garland, Texas.
Thank you, gentlemen, for being with us. We're looking forward to an engaging discussion. In the summer of 2020, the U.S. Supreme Court took a major step in expanding the rights of religious institutions to discriminate in regard to employment. The court had previously, but only 8 years ago, granted religious institutions the right to discriminate against employees who are ministers without recourse to, in order to keep courts from being entangled in theological issues and controversies. But now, on a 7-2 decision, they enlarged the definition of ministers to include anyone in the institution feels in any way teaches or personifies their beliefs. What matters, the majority said, is what an employee does. To find otherwise, the court said, would be to interfere with the internal church governance. The cases decided involved 2 teachers in religious schools. One who claimed she was dismissed because she had cancer, and one who alleged she was terminated because she was over 60 years old. Both spent the vast majority of their time with students teaching secular subjects. Neither had any training in religion or anything approaching spiritual preparation for ministry. Both were in positions titled lay teacher. Neither were even active members of the religious body with which their school was related. So we're going to ask our panelists to discuss these questions. Number 1, are teachers in religious schools truly ministers in any way more than other parishioners or even parents? 2, using the court's reasoning here, should teachers at religious schools also be allowed certain clergy tax benefits like parsonage allowances? And 3, is the so-called ministerial exception itself unfair as it allows termination of employment for reasons both religious and non-religious, both benign and bigoted, without recourse? And so we enjoy beginning this discussion with Bishop Michael Olson.
Thank you very much. This is a very important point, I think, and all the issues raised show it not only its complexity, but the fundamental principles at play here. The First Amendment protects the right of religious institutions to decide for themselves, free from state interference, matters of church government as well as those of faith and doctrine. Now, in employment matters, we are held to the same sort of employment laws when it comes to remuneration, when it comes to other issues involving non-religious functions as everybody else, all right? We're taxed on property as long as when it's not being used for religious purposes. Many people don't know that. I pay income tax on my salary as well as every other cleric here. Clergy, in fact, are listed as self-employed, which actually is discriminatory against me because I'm not self-employed. Because if I was self-employed, I could go and work for whoever I wanted to work for. But the tenets of my faith don't hold that. So there are all sorts of these distinctions which require, in a sense, obedience and compliance with the secular authorities, but also maintaining the integrity of our religious faith. For a Catholic perspective, Catholic schools have always been a ministry, and they are part and parcel of our religious identity and mission. They're a spiritual work of mercy in instructing the ignorant and teaching them, and also in passing on the tenets of the faith in every area of life. And so discrimination is really, I don't think, that's a loaded term that I don't think applies here, because what you're measuring is behavior and the passing on of ideas that are contrary to what the church teaches and has taught for more than 8 years, for more than 20 years, for more than 50 years, but throughout history. And so we have a responsibility to pass that on. The ministerial exemption is something that has been applied to this only after the Hosanna Tabor decision. Really, prior to that, it applied to others besides just those engaged in ministry. But from a Catholic perspective, everyone working in a school in some ways is tied into the ministry of Catholic education and is not a cleric, doesn't have the identity of clergy, but through baptism has the responsibility of ministry, which includes lay ministry, which calls upon each person to have the responsibility of living in accord with the norms and teachings of the church.
Tom?
Thank you. I'm not sure that I disagree with one thing that the bishop said. I just agree with the dissenters, the two dissenters on the court here in this particular case. In this case, actually, this is a combination of two cases. Not just one, and the Supreme Court often does that. When the issue is the same, they will combine cases, and in these cases, neither time did the religious entity that was terminating the employment of the plaintiff make it in any sense on religious grounds. It wasn't because they had not been good teachers of the particular faith of the institution when they had responsibility to do anything about that. In fact, they didn't have hardly any responsibility at any time during the day to do any of that. It was kind of like, came over the loudspeaker. Well, it's time to have prayer, and the teachers were required to say to the students, let's bow our heads. It was not that they were teaching religion particularly. And yet, because of age, one of them, I believe it was, one of the plaintiffs was terminated because of her age. At least that was her contention, and the other was terminated because she felt because she had asked for leave in order to get cancer treatments, because of which she eventually died. She died before the case was decided, actually. and in neither case was there any religious issue at play. It was they were pure and simple employment decisions. And what the court did, what the majority did, was to take the ministerial exception, which is a rather young in the history of the United States a concept, which was decided just a few years ago, that for ministers, the religious entity can hire and fire willy-nilly for whatever reasons. And what the courts did in this case was to expand the reach of who is the definition of who is a minister, and I think they overreached. I think they went too far in saying that basically anyone who says anything about religion in the religious institution is a minister, and therefore the ministerial exception applies, which meant in this case that the courts should not even hear the case. Okay, not that the case should be decided in a certain way, but that the courts should not even receive the cases. So that was particularly egregious from my point of view. And we require religious entities, as Bishop Olson said, to pay their Social Security, their part of Social Security for their employees, but not for you and me. We require them not to discriminate on the basis of race, and we enforce child labor laws on religious entities. But all of a sudden now we've expanded this notion of what a minister is to folks that really, when you look at the facts of what was going on in the careers of these two women, these two plaintiffs, didn't have much of anything to do with the teaching of religion.
Tony?
This is a very complex topic. I appreciate both comments. I have more questions than answers. One thing I will say, though, that's troubling to me is no matter where the people were teaching in a secular or religious institution, if they're male or female, or if they're teaching religious topics or topics that are not religious, I have a challenge with why they were fired. I mean, the age and the illness, I think that alone is so, I think it's an ethical, moral challenge there. I'm still sifting through. I understand why the ministerial exception came in. I don't know if the court slipped out of this one and just, but I think there's a challenge with terminating people because of their age. And then I have a friend, this is dear to me because I have a friend who has colon cancer. And this friend was a manager at a restaurant for a couple of decades. And when he got colon cancer, he had to have treatments, and he was, he couldn't go into work all the time. And they terminated him. And all those, it's just such an ethical, moral thing. Now, legally, biblically, the term minister can be argued. It can be argued that everybody's a minister. We all are servants. We all minister. Of course, in the Baptist tradition, in some Baptist churches, It's male leadership, which you know, of course, that's up for debate in terms of quote unquote the minister or the pastor, I should say. But for this case here, my main problem is that they terminate these people because of age and illness. I think that is something's wrong with that, and I wish they would have weighed in, unless I've missed something, that they would have weighed in on that component rather than the ministerial exception.
Carl?
What makes it even more heinous is it's done under religious justification, which makes it even ickier, because, or just plain wrong, because those exemptions for religion are there for a purpose. That is, namely, that you mentioned, Michael, to protect us, right? Those are practice of religion under the First Amendment. And I believe that they've expanded the definition of minister. They followed, in a weird way, the American thing that everyone's a minister, so therefore everyone's evidently is can be legally defined such. I just think it's too much of an expansion. In the Lutheran tradition, you have theologically trained people, some who are pastors and clergy, but you also have teachers who are theologically trained as well. And those are considered ministers of religion officially on our roster. But we have people, for instance, at Concordia who are just that. They've been theologically trained and they're teaching science. I think it might be fair in that circumstance to qualify them as a minister of religion. They've been theologically trained. But there are a lot of people who are just faithful lay people who are there. They believe in the mission of the institution, which is inherently religious. Concordia has a specific religious mission. But they're not theologically trained, and to me, all the employment law should apply fairly to all of those people, even though they're teaching at an institution whose mission is religious. That's theirs as an employee, perhaps, but they are not theologically trained and shouldn't be defined as theological.
I think I agree with you. It's, you know, I think, again, this is a contention of those who took the case to court.
Yeah.
All right, so I'm not sure if there were other things withstanding or not in regard, and it would be morally wrong and abhorrent and abusive to discharge somebody because of illness or age, and to use this as an excuse to do so. And I think that is immoral and wrong. I think sometimes, like almost every Supreme Court case that we encounter that is controversial, decisions are made to look for an extension beyond the case itself. What are the principles at play? And everything from Roe v. Wade to Griswold versus Connecticut to more contemporary decisions as well carry with it that sense of where freedom clashes with social responsibility and nature and these sorts of things. I think, though, this is it's a lot like to take it away from just religion for one moment. I think courts face the same thing when it comes to the practice of medicine. It's a principle that they hold that doctors are judged by a standard of care, and in their judgment of a standard of care, the court says, we judge this only by what the governing professions or guilds say so. And then they proceed to make a law, like on things like advance directives or everything, and medicine soon gets practiced in the courtroom. I think there's a wisdom to judicial restraint in general, as much as can be practiced for the sake of good governance of society in every area. And I think the constitutional principle of the First Amendment is invaluable, especially, I mean, when it comes to the integrity of teaching moral doctrine. I mean, otherwise, what would we do and from a Catholic standpoint in our tradition? How do you govern and administer a cleric or a teacher who's teaching his own or her own thoughts? And that when people have a right to hear. I mean, without reducing it to "you're in my kitchen, you'll eat my cooking." I mean, it's. I think that's a very important principle.
Tom.
Well, I think another thing that needs to be mentioned is that we are currently in a time of shifting in our nation. There are two religion clauses in the First Amendment. One that says there shall be no establishment of religion, and the other that says there will be no restrictions on the free exercise of religion. Now, the free exercise clause and the establishment clause sometimes clash with each other, and in the current court, we are seeing the court lean heavily on the free exercise clause to the detriment of the establishment clause.
Michael?
No, I agree with Tom in general, and it's just simply, we're also finding that there's a religion now without an established church, and the religion is a dominant secularism.
Very good. We thank you all for your comments, and we'll hear more from you in just a second. But right now, let's move to a message from our sponsor.
We hope you are enjoying today's program. If you would like to learn more about the American Religious Town Hall, please visit our website at americanreligious.org. That's americanreligious.org. There you can read about the mission and history of the program, learn about the town hall estates, and view past programs by clicking the appropriate menu buttons. Each week, Pastor Lutz looks forward to receiving your letters. You may write to him at the address shown on your screen. Send your letters to Pastor Jerry Lutz, American Religious Town Hall Meeting, P.O. Box 180118, Dallas, Texas 75218. That's Pastor Jerry Lutz, American Religious Town Hall Meeting, P.O. Box 180118, Dallas, Texas 75218. Thank you for writing, and thank you for watching. And now, back to you and today's closing statements.
Welcome back, and we thank the American Religious Town Hall. So now we have an opportunity to have our panelists to make their final summations, and we'll begin with Michael.
The First Amendment protects the right of religious institutions to decide for themselves, free from state interference, matters of church government, as well as those of faith and doctrine. In the Catholic tradition, schools are essential for the fostering and development and education of that faith and doctrine, not only in the specified area of theology or religion, but in every area of education. That maintains the responsibility then is for the governance of schools to be done justly by the religious sponsoring body, and also that any interference on the part of the state in that is unjust and an imposition of against religious liberty.
Tom?
Thank you. Well, I would just simply bow to the language of Justice Sotomayor, who was joined by Justice Ginsburg in the dissent on this case, and say that although a person's performance of certain functions may be important to a church's religious identity and mission, a person's performance of some functions does not automatically trigger a categorical exemption from applicable anti-discrimination laws. And she went on to say that the fundamental civil rights of one party has once again been trampled on in the name of the free exercise of another party. And as usual, she said the vulnerable party was the one that was in the line of fire.
Tony?
Yes, we have great respect and honor for the First Amendment. In addition, the application of the same should exhibit some grace and mercy as it relates to the topic that we're talking about. I just have a challenge with someone having cancer and someone being 60 and being terminated. But of course, there's probably a lot more to the case than what's on the surface. And we just hope that we could show some grace and mercy.
Carl?
It seems like always in these kinds of discussions that we have two goods at odds with one another, and they fall down on this particular case. I mean, here you have free exercise of religion. I think Sotomayor said it quite well, and you repeated it. You have this tension between the civil rights of individuals versus the free exercise of religion. And in some ways, I feel like the Supreme Court's trying to step outside and to let religions decide what religion is. But here, I feel like in some ways, they've made that decision.
You know, it's a line-drawing question, isn't it? Where do we draw the line of the court's intervention into religious practice? And it's a very, very difficult question because there's so many fronts in that line of where we draw that. As a lawyer, I look into this a lot, and the line goes the other way. How much may religious practice be limited by non-religious employers of their religious employees? I just feel on this one really strongly that when the state takes their hands off, Paul says we shouldn't go to civil court against other believers, you know, but when the state takes their hands off, it becomes then incumbent on the church to stand in, because Paul's comment goes on to say, isn't there someone among you who's capable of hearing your dispute and deciding? And your church has ecclesiastical law that people can appeal to for that. Most of the rest of our churches do not. And I think it's to our fault that we do not, because we need to provide those kinds of hearings. If the injustice, as you describe it, is violative of all of our consciences, then shouldn't the church hear that internally and say, no, you can't fire those people because of their age? That would be wrong. And so churches, I think, need to really provide that opportunity. Go ahead.
In keeping with their own morality, especially.
Exactly. The morality that's required of our faith, but the that's required by God.
Yes.
We've been asked to be people of character. And Matthew 28 that you quoted in another show, that we're requested to care for those who cannot care for them, the most vulnerable, as Tom said. The charter of the American Religious Town Hall provides that Roman Catholics, Protestants, Jews, educators, and others may appear on this program and can declare their beliefs without hesitancy. And the rest of the members of the panel will uphold and guarantee that American right to all who will appear, irrespective of race or creed, so that the rest of the world can see that here in America, we believe in civil and religious freedom, not only in theory, but in reality. And now, friends, until next week at the same time and over the very same channel, the American Religious Town Hall meeting stands adjourned. May the God of all of us bless all of you.
Until